In this video, I will tell you what you need to know about whether it's actually safer to operate in Florida now from a litigation standpoint following Florida's tort reform. I'm Santiago Cueto, board-certified international business law expert and best-selling author. Florida recently passed some of the most aggressive tort reform legislation in the whole country. Business owners are celebrating. Insurance companies are breathing easier. But here's the question that no one's asking. Does this actually protect your business, or are you still walking through a legal minefield? I've been practicing business law in Florida for nearly 30 years. I've seen the before, and I've seen the after. Today, I'm going to give you the truth about what these changes really mean for your business. Let's start with what actually changed. Well, a couple years ago in March of 2023, Florida passed House Bill 837. This wasn't some minor adjustment. This was a complete overhaul of how personal injury and negligence cases work in this state. The old Florida was a plaintiff's paradise. If someone got hurt on your property or because of your product, they could file a lawsuit years later. They could sue you for damages even if they were mostly at fault. Their attorney can negotiate with your insurance company before even talking to you. It was a system designed to encourage lawsuits. Well, the new Florida law looks very different. The statute of limitation for negligence cases dropped from 4 years to 2 years. That's huge. It means injured parties have half the time to decide whether to sue you or not. Florida also switched from pure comparative negligence to a modified comparative negligence. Under the old system, someone could be 99% responsible for their own injury and still collect 1% of damages from you. Now, if they're more than 50% at fault, they get nothing, zero. The case gets dismissed. Here's where it gets interesting for Florida business owners. The new law eliminated one-way attorney fee provisions in certain cases. Before, if someone sued your business and won even $1, you had to pay their attorney's fees. But if you won, you paid your own attorney's fees. That asymmetry encouraged lawsuits. Now the playing field is more level. Medical malpractice cases also changed dramatically. Letters of intent are now required before filing. Pre-suit investigation periods got shorter. The bad faith framework for insurance disputes was completely rewritten. These changes matter even if you're not a doctor because they signal how Florida is treating litigation overall. But let's talk about what this means for you specifically. If you own retail space, your slip and fall exposure just decreased. Those cases now have a shorter filing window. Plaintiffs who were partially responsible for their fall face higher barriers to recovery. If you manufacture products, your liability window shortened. If you operate a service business, the changes to attorney fee provisions mean fewer frivolous claims. The economics of suing your business just became less attractive for plaintiffs' attorneys working on contingency. This sounds great, right? Well, Florida is now business friendly. You can operate with less fear of litigation. You can stop losing sleep over potential lawsuits. Now, if you're finding this information valuable, do me a favor, hit that like button right now. It helps more business owners find this content, and subscribe to my channel because I break down complex legal topics like this every single week. You need to hear what comes next. Here's what the tort reform cheerleaders aren't telling you. These changes don't eliminate your liability. They just change the rules of engagement. You can still get sued, you can still lose, and you can still pay massive damages. The 2-year statute of limitation helps you, but it doesn't protect you from legitimate claims filed within that window. The modified comparative negligence standard helps you, but it doesn't protect you if your business was primarily at fault. Let me give you a real-world example. You own a restaurant. A customer slips on a wet floor. Under the old law, even if that customer was texting and not watching where they walked, they could recover damages from you. Under the new law, if a jury decides that customer was 51% responsible, you win. But here's the catch. You still had to defend that lawsuit. You still paid attorney's fees, and you still spent time in depositions in court. The tort reform saved you from paying damages, but it didn't save you from the litigation process. And what if the jury decides your restaurant was 51% at fault? Maybe you didn't put out a wet floor sign. Maybe your employee mopped during peak hours. Maybe your lighting was poor. In that scenario, tort reform doesn't help you at all. You still lose. And here's another consideration: insurance rates. Everyone assumed tort reform would lower insurance premiums for businesses. Some carriers did reduce rates, but many didn't. They're waiting to see how the new law plays out in actual litigation. They're waiting to see if fewer lawsuits actually get filed. They're waiting to see if jury verdicts actually decrease. So your insurance might not be cheaper, your coverage might not be better. You're just operating under a different set of rules. Now let me tell you what you actually need to do. Stop assuming tort reform is a shield. It's not. It's a tactical advantage in specific scenarios. You still need robust risk management. You still need proper insurance coverage. And you still need to operate your business with reasonable care. Document everything. If you run a premises-based business, document your safety procedures. Document your maintenance schedules. Document your employee training. If someone does sue you, that documentation is what proves you weren't negligent. Review your insurance policies. Make sure your coverage limits match your actual risk exposure. Tort reform didn't change the potential size of jury verdicts against you. It just changed who can sue you and when. And train your employees on safety protocols. The best defense against litigation is preventing incidents in the first place. Tort reform might help you if something goes wrong, but preventing things from going wrong is still your primary strategy. Now consult with a business attorney before assuming you're protected. Every business faces unique risks. Retail businesses face different exposures than manufacturers. Service businesses face different exposures than landlords. Tort reform impacts each differently. The bottom line is this: Florida is more business friendly than it was 2 years ago. The litigation environment is better for defendants. The economics of filing frivolous lawsuits are less attractive. But your business is not bulletproof. You're not immune from legitimate claims. You still need to operate with care, maintain proper insurance, and document your risk management efforts. Tort reform changed the game, but it didn't end the game. Now, if you found this breakdown helpful, hit that like button and subscribe to my channel. I break down complex Florida business law topics every single week so you can operate with confidence. I'm Santiago Cueto, your Florida business attorney. Be sure to stay and watch more of my videos right here.